This one.
What?
Is that on?
Yes.
Okay. All right. Give us some hearts if you guys can hear us, please. TikTok.
A way to go back and
All right. So we got YouTube, TikTok, Facebook, all live right now, and we're gonna talk a little bit about what happened yesterday. So, Jessica here. Have at it.
What?
So, all right.
All right. Yeah, you can go.
No, go
No,
ahead.
you can
Go.
go.
No,
You're better. You're better at talking.
I'm not. I'm not. Am I better at talking, you guys?
Well,
Come
sure.
on now.
I'm gonna say give him a hand for that.
Okay. Jessica here. So yesterday, if you guys aren't aware, yesterday we were in Blount County, Tennessee, and we were there because Jessica had some family court stuff that she was dealing with, and when we got there, we came into the courtroom, and maybe 10 minutes after we got into the courtroom, the sheriff came in and pointed at her and said, "Come out here." So she came out there, and she was met by two agents from Department of Homeland Security. And those two agents took her in the interview room right there and kept her in that interview room for an hour and a half, interviewing her for some alleged crimes that came in as anonymous tips that just happened to come in that week. Which is, I mean, we know where it came from, and we're going to talk about that, because a couple of things I want to get out today is I want you guys to understand the standard operating procedure that they're using, how this damn indictment or absence of the indictment by a grand jury, how it relates to these family court issues, because they're directly related, you guys. They're directly related. They use this the criminal court system in order to advance the family court matter, and they're doing it all across the country. Cash Jackson, you guys know him. Same thing happened to him. Same thing happened to me, right? They use the criminal system in order to keep you from being able to come into your family court matter so that they can end the disposition of that dispute in favor of the party that the court wants to win. And then they use that criminal matter as a mechanism to be able to say, "See, I told you," right? And justify their behavior, their unlawful acts. But that's what it was. That's exactly what happened. But before we start, I do want to say today, guys, today is my son's 18th birthday. And last time I saw or talked to him, he was 8 years old. And it's been a long time now. But Hunter, happy birthday, son. Someday I hope that you'll be able to understand what I'm doing, why I'm doing it. I love you very much. I always have, never stopped. And one of these days, you will know the truth. Happy birthday, son. I mean, that's the best that I can give you right now. Happy birthday. Love you very much. So Jessica here.
So, I want everyone to know that I knew when I walked into that court what my main goal was. And I also knew that the state had already taken a position and a side against me. So I didn't expect to go into that court walking out with the big hoorays, thinking that I was going to actually have an order where I could be reunited with my children. Okay, so that's the first thing. Second thing is, I was supposed to have court, originally it was docketed Wednesday through Friday, full days. I got word from another mom in Blount County that she had her court case that was also docketed on Wednesday starting at 10 when I was supposed to be all day starting at 9, same day on Wednesday. So we already knew that something was up, and we went in. I went in with one goal in mind, and that was to, one, get out without being arrested. So I did tread, carefully and lightly, and I was as respectful as possible with the law enforcement officers and wading through the courts. The other reason why I went was because I wanted to get more evidence on the record against the judge that she's committing crimes against the people of Blount County. This wasn't just for me. This was in relation to all of the families that I have heard from, talked to, interacted with in Blount County specifically, and I wanted to get that evidence on the record against Judge Harrington. Both of those things were fulfilled. We got out of court. I am not arrested, thank God, and that was all by the grace of God. I'll explain that in a second. And I did get some evidence on the record that she once again perjured herself. So there's a couple things that these courts and these judges, they're doing it on purpose. And one of these things is immediate intimidation. So when we first got there, we first walked in, I wasn't allowed to bring in my briefcase. I had already gotten approval that I could bring my phone and my computer into this court, which that never happens. I've heard from multiple families who have attempted to do the same thing, even though they're in their pro se or sui juris or whatever, they're representing themselves, and they're not allowed to do that. I was able to do that. However, I had to keep both my phone and my laptop turned off, which is not what the attorneys do. So that was a big issue.
They just wanted your phone.
They did. We actually took my computer and my phone back out to the car. I walked back in just with my phone, but nonetheless I still had to keep it turned off. So that was one thing. Another thing I wasn't allowed to bring in was a recording device. Everybody knows that these courts are recording us. So if they are recording us, and then they're going to be the custodian of that record, and we all know how easy it is to alter and amend some type of an audio recording. It's so easy, guys. Why can't we also take these recording devices in and protect ourselves and protect the truth when all this stuff is going on behind closed doors in silent court that's closed? It should be public. I previously petitioned this court. We had, I believe, 7 affidavits from court watchers across the United States who actually sent affidavits in saying, hey, I am an advocate on behalf of Jessica Saxon and her children, and I want to be present in that court via Zoom. If you want to vet me or make sure that I'm part of an advocacy group or whatever, that's fine. And the judge denied it. She said no. And she actually threatened me in court, saying that if she found a recording device or that I was live broadcasting any of this public hearing, that she would find me in contempt of court and take me off to jail immediately. So,
However, 14th Amendment, law must apply equally, you guys. You can't have one party be able to record and video, all of that, but not the other party. It still is an equal protection issue. Government cannot create laws that affect only government, not enough people. But more importantly, what is the purpose of the video and the recording in that courtroom? Why did the people pay the money to put a damn video camera in the courtroom? Was it not to protect the people? Right? That's not equipment that's there for the fucking government. That's not there for the protection of the state. That's there for the protection of the people, right? That's our equipment. Therefore, the product that comes from that equipment is ours, the people. It's not the courts. That's not the judges or the count. That is our video from our equipment, paid for by us, the people. Therefore, the product that's produced from it is our product, not the courts. They got that one wrong.
yeah, way wrong. So intimidation tactics, all the way through. Guys, they didn't think that I was going to make it to court. They thought that this miscellaneous tip to Homeland Security about me threatening the judge on some type of forum almost a month ago, they thought that I was going to be arrested on federal charges and I was going to be hauled off. And that's why I wasn't on the docket when I was supposed to be Wednesday, Thursday, Friday. Did you have something to say? No. Yes, no.
No. Well,
Go ahead.
Go ahead.
So we get into court. I already knew that something was up, and they haul me off into this room, and they start talking to me. Now, they did tell me that I was free to go. The Homeland Security agents, they said, you know, you're free to go. You don't have to answer any questions. But I saw on the table that there was a paper that was completely filled out with the agent's name, all the signatures, everything except for mine, and that was a Miranda rights piece of document.
Now, as she's going through this, let me explain what's going on, right? So first off, she wasn't free to go, right? She wasn't. They got an anonymous tip late last week that she had allegedly threatened to harm the judge in that case, right? Didn't happen. Never happened. We would never ever advocate for violence. We never have. We never will, right? But it was an arbitrary and capricious anonymous tip raised last week, the very day that they told her to be in there on Tuesday for her alleged trial or jury trial on Wednesday and Thursday. But then we find out that she's not on the docket for Wednesday or Thursday because the court presumed that she was going to be under arrest on Tuesday, right? In fact, the judge came out and was surprised that she wasn't under arrest because they're used to being able to arrest people on information, right? That's all it takes. That judge can call up the FBI or DHS, provide an anonymous tip and say, oh, I saw that she was on some live a month ago and she threatened to harm a judge, allegedly, right? And that right there is enough to perform an arrest, and that would have tied her up for the next 10 years. Ask Cash Jackson. Ask me. It tied me up for 4 years. Not the same thing, but that's what they do. Now, you guys, she was not free to go. But why did that agent tell her that she was free to go, right? So that they didn't have to Mirandize her, right? So they don't have to. So that they can have a casual conversation without having her have certain rights. Because if she were detained, then she has rights, right? And he has to make sure that she knows those rights. You have a right to remain silent. You have the right to counsel. You have all these things that maybe or maybe she wouldn't have invoked those rights, but at the end of the day, they didn't want her to be aware that she had those options because he wanted to just simply get information from her so that he could arrest her. God, this is what they do, right? This is what they do. And this is the indictment issue, and as she goes along here, I'll continue to point out. But that is their standard operating procedure. They're going to tell you that you're free to go. She was in no way free to go. No way, right? Now, what's interesting is that as she was taken in there, I asked if I could come too. I said, I want to be there to observe. And they said, no, you cannot come with her. And then they told me I have to leave the courtroom. I have to leave court there. I couldn't be in there anymore, right? Now, you also got to remember, one other thing is that they said that these comments, these alleged comments, were made on my TikTok or my Facebook Live. Mine. So I'm curious, why was I not being detained as well? Why didn't they question me? Right? Which kind of ties in a little bit here, but continue on. Standard operating procedure, guys. We'll wrap this up as we go through.
So we get in there and they start asking me questions, and I was honest with them about everything. And it's a situation where you have, the adrenaline's running, you want to start talking about everything and everything. I will have to say that the agent, he was constitutionally focused, and I think that by the grace of God I got out of there, because had I not had a morally and ethically strong individual, I'm not sure that this would have ended the same way. So that was 100% God protecting me, and that's all I'm going to say about that. This didn't have anything to do with what I did or didn't do in that regard, because there are people that we know that are in prison right now, 5, 10, 15 years, based on the same type of allegations and things that they did not do. So I'm not saying that this was anything that we did. This was 100% God, and that's the reason why I'm out today. We had spiritual protection like no other yesterday. And
But do remember here that this absence of the indictment issue, the information issue, was exactly what they were doing to her, right? They had information from the state, right, from an anonymous tipster, but we all know that there was someone within that court, right? Because that court did not want to have to address her constitutional issues that she had raised. So what better way to make it go away than make her go away, right? That's what they were doing. They were using the criminal system to make it go away because they couldn't respond to her constitutional argument. Guys, they can't respond to things that I'm raising here. Article 3, absence of the indictment, right to a jury trial. All these things are written in the Constitution. They're written for all to see, incorporated by the Supreme Court, right? And yet, they don't want to do them. They don't want to do them because they already have a predetermined outcome, and that predetermined outcome was that Jessica here loses, right? Loses everything. They're going to take all of her property, they're going to take her children, all of it. But my point is that this indictment issue, this absence of the indictment issue, this is what's happening to all of you. You know, these parents, these mothers, they're getting arrested. The father's getting arrested. You're being arrested on information, right? An allegation, simple, that's not even founded, that has never been verified, that you've never had the opportunity to confront. And what are they doing? They're arresting you. And why are they doing that? So that you don't get to go into that family court hearing, and that way they can do whatever they want. Because if you're not able to be there in family court to confront the allegations that are against you, then they award to the opposing party. I lost everything, because I couldn't be present in the family court hearing because of this alleged criminal complaint that I'd gotten, right? And if I'm not present, awarded to whatever. It doesn't matter what they say, it goes unopposed. And any accusation unopposed is truth. So they use the criminal system on an allegation of information collected from an anonymous source, right? And let me ask you guys, how can you confront your accuser if the accuser's anonymous? Right? How can you do it? You can't. That's why we're fighting this issue.
Guys, I would never say anything about a judge. As a matter of fact, we steer away from that. We block people immediately. If I see a comment on this stuff, you're going to be blocked about harming anyone. And there's some things that I know that you guys say that are borderline to that. I think after this little interaction, if there's anything borderline, rising up in arms, any type of bullshit like that, we are moving forward peacefully. We want this to go the right way. We're not here to cause harm to anybody at all. So I'm going to block anyone that I feel like is crossing that line or getting even close to that line. So we got to keep all of these comments about the Second Amendment to bare minimum. We're moving with love and peace, and that's it, in a lawful manner. Otherwise, we're going to end up, whatever. So they let me go. What?
Well, and also remember, like, when the NAACP was dealing with Plessy versus Ferguson, this was 1958, 1957, Brown versus Board of Education, right? So Plessy versus Ferguson was the segregation in the South, okay? So legalized segregation, and it came from 1882, a decision from the Wake Court. Wasn't okay, it wasn't all right, but nonetheless, that's the decision the court made to create the hostility and conflict across the country. My point is that when Dr. King was dealing with Plessy versus Ferguson, because he was trying to address that, and so what he was doing was not just Dr. King, but all of them. They were going to union meetings because they started out with unions, right? Lots of the garbage workers union down in Alabama and stuff. So they started with unions, and so Dr. King would go into a union meeting, right? And he'd be talking to them about the situation, and their strategy back then was they would take a state patrol officer and send them in undercover into this meeting. And then that undercover state patrol officer would make comments, right, that would be inflammatory, right? So like, let's go out and da-da-da-da-da, right? And what they were trying to do is they were trying to get the people in that meeting to agree to it. Like, oh yeah, that sounds like, let's do that. Let's go and da-da-da-da-da, right? Because if they did, then the state would be able to label them an insurrection group or a terrorist group and thus come in and arrest them. So Dr. King was very, very proactive about making sure that if someone came in and made those comments, oh hell no, you get the fuck out of here, because that's not what we're doing. And that's not what we're doing here either. Not at all. Guys, this is a peaceful assembly to petition the government for redress of grievances consistent with the rights that we have codified in the Constitution of the United States of America, preserved and incorporated by the Supreme Court. We have the right to do what we're doing, to speak out in the manner that we're speaking out. But in no way, shape, or form are we inciting violence? Are we insinuating violence? Are we supporting violence? Absolutely not. We're going to win this without violence. They can bring in all the violence that they want, but we're going to remain peaceful and we're going to win. We're going to win easily, but we're not going to permit people to come in. So there's already been some comments that have been brought in. I'm identifying plans that are coming in. I want you guys to be aware, this is their strategy. If you want to predict the future, all you can do is study the past. What they did in the past was they would incite violence, and we're not going to do that. This is not a violent act. We are using the system democratically and employing diplomacy to go out there and to use our words to correct this. And in no way are we inciting, insinuating, promoting, or implying any sort of acts of violence toward anyone whatsoever. Never. And if you guys come on and make any statement, assessment, it doesn't matter how long we've been connected. If you come on and you make a statement that would be misconstrued or could be misconstrued, then I'm sorry, you're going to be blocked immediately.
Yeah. So after they let me go, which it wasn't. I guess it was an interrogation, but it wasn't the type of interrogation that you would see on Hollywood. So people need to be aware that it was a peaceful interrogation. Okay, so they made friends with me. They did all the things to make me feel comfortable, and that was to get me to really tell them what the court wanted me to tell them. But all I told them was the truth, and the truth is not what that court wants to hear. And so because of that, they let me go. I was able to tell them some things that I don't know if I should talk about that.
No, well, whatever you want. I don't know.
No, I won't talk about that.
Then don't.
So, after I left court, after I left the room and went back into court, the judge came out and she was surprised to see me. And she said that apparently Miss Saxton had been being investigated or being interviewed by Homeland Security, and apparently everything is good and everybody's safe and we're here to continue. Guys, they were not prepared for me to be in there questioning all of the violations that I had previously raised. And everybody there kept fumbling over themselves. The judge couldn't tell me one way or the other whether or not she was acting within her judicial authority or not. They were not prepared for me to still be in there and still be faced by me. Now, I did realize that they wanted me to be gone and arrested, and they didn't want me, and so I ended up, after I did what I intended to do, which was to get the judge on further perjury, oath violations, kidnapping, all of the things. After I left, I went to lunch and I didn't go back. And they were expecting me to go back. I sent a message that just said I rest my case, and that's it. And I'm done fighting in that lower court. These people don't have authority over us. When I was standing in there fighting them in their battleground, I knew that it was going to be by the grace of God if I got out. And so once I got out, I left and I didn't go back. God had me write something night before last, just before I walked into court, and I didn't realize that what I was writing was actually not for the judge. I thought it was for the judge. I thought it was for that court, but it wasn't. This was God preparing me for what was going to happen with Homeland Security. I ended up giving Homeland Security guy, Mr. Hughes, a copy that I was intended to put on the record and give to the two attorneys. But I left it with him and I didn't leave it with the court because God had me write this. But in this letter it's not really legally strong as far as all of the terminology, but this was straight from my heart. And this is what I really intended to do with this judge and with Blount County. And it was basically a cry to say, look, we understand that there is a systemic issue that's going on here in family court, where our rights are being deprived, our children are being invoked by trauma that they shouldn't have to deal with. And there's no family court judge out there that's actually taken a stand to do the right thing. So my plea to her was, will you be that first judge? Will you make a national stand and basically say that, you know what, you're right? So, can I read this?
Yeah. So she mentioned earlier when I just walked upstairs. She mentioned that we can't fight in their battlefield, right? And the analogy that I want to bring up to you guys is that we all know that we're fighting English tradition, right? The bar association. We know what it is. There's enough evidence out there. We're not going to go through it. The British Accreditation Registry. We know that. Now, the big reason why English judicial philosophy has seeped its way, permeated its way here into America is that here in America we have a separation of powers, right? We have legislative branch creates all legislation, all legislative power. That means legislation is law. So all power to deal with law vested in branch number 1. That's make, amend, or destroy law. Everything that has to do with law is done by the first branch government. Second branch government is the executive branch. That is there to enforce the law. It's the enforcement branch, right? They don't create law, they create orders, executive orders. But orders is not law. Orders only affect those that can be ordered. So orders only affect those that are within the executive branch, the ones that the executive officer can order, right? The president can't order the people, right? Because he's a servant to the people. So executive orders, don't get it wrong. Those don't affect people. Only law affects people. Legislation is all that affects people. Third branch government is the judicial branch, right? They are there to administer the laws. They are the administrative branch. So, and they create rulings, not law. They create rulings, judicial rulings. But rulings are not law. Rulings only affect those that can be ruled over, which are administrative officers, right? Members of the administrative branch. That's why an attorney is an administrative officer of the court, because they follow administrative law, because they're ruled over by judges, right? They're administrative officers. They follow administrative law. What does that have to do with English jurisprudence? Well, this. Here in America, right, we did not delegate the authority for the judicial branch to have any legislative power. Clause 1, Article 1 of the Constitution says all legislative power is vested in Congress of the United States, consisting of a Senate and a House of Representatives. All power to make, amend, or destroy law is vested in the first branch of government. No other branch of government has any constituted authority to deal with law, right? So here in America, judges do not make law. You do not legislate from the bench here in America. You do in England, right? You do in England. Because in England, you have a monarchy, right? A king. And that monarchy did delegate his legislative authority to his officers, the judges. So in England, right, in English judicial philosophy, the judges do speak the law. What a judge says in England is the law, because the monarchy has granted his agents, the judges, the authority to speak the law. That's where the bar has seeped itself in. That's where English jurisprudence has come in. That's where we have gone wrong here in America, is that judges do not create the law. So when a judge creates a ruling, right, a judicial ruling, and then goes out and calls it law, case law, that is not law. That is an unconstitutional act, because the judicial branch has no authority to create law. You cannot create law. Judges, you fucking create orders. Judges here in America are tethered to positive law. Therefore, their rulings must be consistent with positive law. So we have an absolute English monarchy or English judicial philosophy. It's permeated its way here in America, and that's the problem. Administrative law is made by judges, and administrative officers follow administrative law because that's what they're taught to do. And every one of these attorneys is an administrative officer of the court. That's why attorneys tell you to follow case law. That's not law. That's why they can't even grasp this, because they've been taught English judicial philosophy contrary to American judicial philosophy. Judges don't create law. So the reason why I say this is that we know what we're fighting. We're fighting the British all over again. So let's go ahead and take a look at history, right? Because if you want to predict the future, all you got to do is study the past. How did our founders and forefathers, how did they fight a war against the greatest military force known to mankind, a military force that had never lost on the battlefield? How did our founders and forefathers fight them with essentially pitchforks and shovels? They fought them asymmetrically, right? You did not meet them on the battlefield. They would have been annihilated by a superior military force. They knew it. They couldn't meet them out in the open battlefield. They had to fight asymmetrically. That's what we're doing. That's what I'm doing. I'm not going to go into their battlefield. I'm not going to go into their courtroom. I'm going to fight them everywhere outside of that courtroom, right? We're going to go to city hall meetings. We're going to go to commissioner meetings. We're going to serve them in their office. We're going to come to their doorstep, right? We're going to fight them asymmetrically because that's what our founders did. We're going to follow them. And what they did, they taught us how to fight the British. We're going to fight them the same way. So when she said you don't go into their battlefield, that is why. The British battlefield, the English battlefield, the one that you're fighting against is right there in that courtroom where they're trying to draw you in and we're trying to draw them away, right? They win in that courtroom, but they don't win outside that courtroom, right? We win outside that courtroom. So we're not going to go in. We're not going to meet them in that battlefield. And Jess had to learn that a little bit this week, and I'm glad that she did because that also puts me in a pretty dangerous situation because they knew exactly where I was. I was a sitting duck, and according to some Yahoo plants on here, they knew that I was in that courtroom. They were following me when I left that courtroom, and apparently they were trying to take me down too. But good luck, guys, because you clearly didn't. I got away from you, so whatever. But
Yeah, it was a risk. I knew it was a risk going in, but I still felt like I needed to be there. So
you did, because we learned a couple really, really key things, you guys. One, we learned that there is, in fact, an open FBI investigation and Homeland Security investigation on us, right? Because this guy interviewing her said, talked about me, talked about what we were doing, right? Serving these county commissioners. He said that we're pissing a lot of really high-level people off. Awesome. That's great. Because we all know that that the truth is the only thing that can offend you. So if it's pissing you off and we know that you're a criminal, then, that's fine. So we know that there's an open investigation on us. That's awesome. That's great. We want that because what that means is that they're watching our stuff, right? That means that they're looking at our videos. If they're looking at our videos, right, and they're reading the argument that we have, they're going to realize that there's no way out of this, right? This is written in the Constitution of the United States of America. You can either obey the Constitution of the United States or you are a traitor. It's as simple as that. So, but so we got that. But it's also good to be reminded to keep our heads on a swivel here, And but the other thing is what we're fighting. The information issue was exactly what they brought her in for, and even though they can arbitrarily and capriciously arrest because they do it every single day, they did it with her, right? They didn't. And the fact that they didn't means that something here is working, right? I have a national do not detain. That's why they didn't interview me, right? That's why they haven't arrested me, because they're not supposed to, right? That's power, you guys. That's freaking power. If we can drive around the country doing the things we're doing, pissing off really high-level people, and they can't do anything about it, they know exactly where we're at. We're sitting in a courtroom like sitting ducks, and yet we're still walking around doing what we're doing. That's power, you guys. That's power. We have an unusual amount of power right now, and we need to exercise this power, because if we're pissing them off, that's exactly what we want to do. We want to piss this king off.
yeah, I had the entire conversation / interrogation recorded, and I'll break that up and release that piece by piece. So So my intent to go to that court, and the main thing that I wanted to do, like I said, was get the judge on the record, perjuring herself again. And then I wanted to attempt to appeal to her. And so this was the letter that I wrote, even though I didn't know it wasn't for the judge. It was actually for the Homeland Security agent, because, you know, he basically said, do you have any intent to harm the judge? And I was like, no. And we got into the interrogation, and not too far in, and I said, here's my letter for this judge. You can read it. This was a heartfelt letter that I wrote, you know, last night, just trying to appeal to her. So, and this is also to the families. I think I saw some families from Blount County on my TikTok here. This was written specifically for Blount County, but this is what I would say to every judge in every family court. And this was the appeal that I would make to every judge. So I'm just going to read it. I said that I'm here today in reverence to a principle older than any seat of power before us. Dear lex sed lex, the law is hard, yet it is the law. It binds the vulnerable and the mighty alike. And in that equality lies the magistrate of justice. I have walked the streets of Blount County. I have listened. Parents, grandparents, aunts, uncles. They speak in hushed astonishment at the plantation that seems to turn children into line items. The damage is not abstract. It lives in empty bedrooms of fit, loving parents, in report cards that no longer come home, years' worth of Christmas gifts piled in a corner, birthdays that are celebrated through bulletproof glass, if celebrated at all. So, Judge Harrington, we cannot pretend that the Saxon v. Saxon case is isolated from a wider commerce in human and childhood trauma. When the records show egregious acts of deprivation of rights, the court must ask whether it stands on ground still fit to bear judgment. Equity says no, the Constitution says no, and the common good for humanity says no. My child's recorded plea still lies unheard. Her truth is still muffled. Around that silence is a storm of fraud on the court, acts of perjury, concealed assets, stolen property, truths not allowed to be told, and deprivation of rights under the color of law, each an offense that corrodes the very foundation of this nation. Given this record, tainted, incomplete, unworthy of final judgment, there remains one path that is consistent with moral integrity and the supreme law of this land. You can either dismiss or grant a jury. To dismiss or grant a jury is not failure to fulfill. It is to honor the higher duty to justice when the process has been poisoned. With respect to truth and justice, I have now placed the most pertinent truth before this bench, though the truth remains untold. And if the court declines to cleanse this case of its impurities, to protect the children, to return unlawfully seized property to its rightful owners, and to yield to a jury's wisdom, then the law itself commands that there is no lawful jurisdiction. Now, as soon as I said this, she stopped me, and she was like, it sounds like that if we break for lunch, you're not coming back. And I was like, well, just let me finish reading my statement here, and then maybe we can discuss it. Anyway, I said, I will then speak no more on this forum, for the record is far from complete, but complete enough to prove that constitutional violations, gross negligence, dereliction of duty, and wanton malice is already on the record. There is then one honest course: to dismiss these proceedings with prejudice, or refer the entirety of this case to a jury of our peers. Some will say that such a remedy is drastic. I answer that nothing is drastic when measured against children's rights to association with their parents and the public's faith in this court. We have tens of thousands of people watching and waiting for one family court judge to step up, signal a new positive light to those who have sat in the nightmare of family court, wondering whether anyone in power can still hear them. I have spoken plainly with respect due to this tribunal. I will add only this. Judge Harrington, if this court takes the path of truth and light over profit, dismissal, restoration, protection, and jury, my purpose here is fulfilled, and I will leave in silence, trusting once again that the justice remains and that another state inferior court will follow. If the shadows remain, I can no longer lend legitimacy to a forum emptied of lawful authority, and I will withdraw, turning to the remedies of our Constitution and federal law that they keep in reserve for such an hour. The choice rests not in my words, but in your wisdom, in your duty, and in your obligation to the people of Blount County, Tennessee, and this great nation. I trust this court will be remembered for the children whose voice it finally allowed to be heard, and for the families that it spared further anguish. for the day that Blount County's courthouse becomes a beacon of hope and healing instead of a battleground fostering hostility. I said, let justice be done though the heavens fall, the law commands no less. Thank you. And that was my last words, pretty much in that court. And then I went to lunch. On my letter that I wrote, I said that I rest my case, but being that the judge was pretty stern about you either tell me that you're coming back here after lunch or we're not going to break for lunch, and me knowing that I needed to get out of there, I didn't say I rest my case until afterwards. I sent a message after I left, and I told them that I'm done. I'm done fighting in your court, and I left. But that was my plea. I was there in love, and I was there in an attempt to be the light in that darkness. And I gave her an opportunity. You know, I told her, just because you admit that something has gone wrong in this court doesn't mean that you're admitting that you're a failure, that you're wrong. I gave her a way out, and that's what Tanawah was saying. You can withdraw from these things.
All we can do, we cannot prevent them from exercising their power, but what we can do is we can draw a line in the sand. We can say this is what the law is, right? This is the law. You guys are clearly operating outside of it. It's up to them to decide which side of the law they want to be on. But once we show them the law, if they don't return to established rule of law, they are then knowingly and willingly engaging in that criminal behavior. Period. And a criminal is one who transgressed the law. That's the very definition of a criminal. So if you transgress the law, it doesn't matter what law it is, if you transgress the law, you're a criminal. She told the judge, this is the law. This is what the law states, judge. And I can't keep you from doing whatever you're going to do, but what I can do is I can show you what the law is. And if you continue to proceed outside of the law, then that is unlawful, and you're now a criminal. Judge Harrington is a criminal, 100%, absolute one, without a doubt, right? And her fate is up to a jury because we do stand by the law, but that's what this is going to come to, because she made a decision yesterday, and that decision, unfortunately, is illegal. It's unconstitutional. And it is, in fact, the crime of treason committed in open court in front of 2 or more witnesses, according to the Constitution. So, it is what it is. Just like she said, Duralex sed lex. The law may be hard, but it's the law. We will not compromise on the law. The law is what it is, and judges don't get to cross it any more than anyone else. That's according to Cash Patel and Senator Kennedy in the video that we have. But I also want to say this, right? These family court judges, they say, oh, Constitution doesn't apply to my courtroom. It's not true. Not true at all. Judge Harrington, right, from Blount County, she is a criminal judge. She deals with criminal matters and family matters. She started out as a criminal judge. What is the oath that they take, right? The oath that they take upon entering into their office as a criminal judge is, I will defend the Constitution, right? Their code of canon, right? Their canons, judicial canons, requires them to obey the law. That's Canon 2A. Judges may use discretion, but they must obey the law. Must obey the law. So they don't get to change hats, right? They don't get to say, okay, in this proceeding, I'm a criminal judge bound by the Constitution, but in this proceeding, I am a family court judge bound by nothing, right? They don't get to do that. They can't switch hats, because when you are a judge, you're a judge at all times according to their own canon, right? That means if there's an act of impropriety outside of there, right, because you're out, at some strip joint at night, right, that's an improper action that would not be becoming of a judicial officer. Are you not bound by that canon at all times and in all instances? You don't get to pick and choose when that canon applies? No, that's not how it works, judges. It's not how it works. It's not how it works. So you don't get to pick and choose which hat you have on. You don't get to say that today I'm a judge, but tomorrow I'm a commissioner, because if you're a judge, you're always a judge in all capacity, right? That's not how this shit works. So, you know, what happened to, or what happened to Jessica yesterday, when it comes time for me to actually be able to access the evidence that I need to access, or the systems I need to access, you know, one of my masters is in information security. We're going to be able to know where that anonymous tip came from. It came from a computer or phone, and that phone is, there's numbers that are associated with that, and we're going to be able to know where that came from. You know, you guys might think that you're smart, judges or whoever it was that made that anonymous tip, but you're not smart. You're not, because that evidence is available. And not only that, but that Homeland Security officer was already privy to the fact that this is very strange, that this tip would come in a month after this incident allegedly occurred, but it happened to come in the week or the day that she was told to come in on Tuesday, when she had hearings on Wednesday and Thursday, and we find out that those hearings on Wednesday and Thursday were already canceled because the court had already presumed that Jessica here was going to be under arrest, right? This is very, very circumstantial evidence that we will have absolute hard evidence once I'm able to get into that system and actually do an audit of it, because that's also what I'm trained to do. So, you know, you guys are not that smart. The tactics you are using is not, you're not going to be able to get away with this, right? But you guys might think you're smart because you guys have been getting away, but your days are numbered right now. You're absolutely numbered.
Yeah. So that's it.
Okay.
That's all I got. I'm thankful that I'm out and not part of that. It was a pretty stressful day yesterday.
So let's talk about information again, guys. So what are they doing here? All right. So information is when you when someone calls up the police or someone calls up the authorities, they say, "Oh, I have this information of a crime, alleged information of an alleged crime." So they call up the authorities. The authorities then take that information and then they use that information as a charging instrument against you. They charge you with a crime based upon information. It's well known that when you're charged by way of information, your right to confront your accuser evaporates, because you can't put information on the stand and cross-examine it. You see, the state becomes your accuser the moment that they use information as the charging instrument, because the state has the information, therefore the state is going to prosecute you based upon the information. But the state wasn't a witness. The state just took information. This happens all the time. You know, a bunch of the mothers that we're dealing with, a bunch of the fathers we're dealing with, Cash Jackson, you know, myself, this is what they do. They take information, right, from an anonymous source, and then they say, okay, here, we're going to charge you with this information, and now there is no accuser. You don't have the right to be able to confront your accuser. It evaporates, it's gone. Now, what this does is it sets up an irrebuttable presumption of guilt, okay? At common law, an affidavit at common law is considered truth, right? So if you do an affidavit of truth, that is truth. And truth can't be rebutted. So when the state charges you by affidavit, it's known as a trial by affidavit. Now this is the founders and our forefathers, this was one of their greatest concerns. This is what led to the Boston Tea Party. This is what led to the Revolutionary War, was exactly this situation right here. Was that the king was using affidavits from his officers to bring people into judicial proceedings, right? This was the taxation without representation. This was the stamp tax, right? So the king, he couldn't find anybody, he couldn't find a jury that would find anyone guilty of the stamp tax because it was so unpopular amongst the colonists. So what he did was he allowed for trial by affidavit. So now the affidavit comes in, right? And they accuse you of the crime, and then you're brought into an arbitrary, a capricious proceeding where you don't have an accuser, you don't have a jury, and you're found guilty because the truth stands unrebutted, right? You can't rebut it. So if you're charged by way of information, what happens is that you're not given the opportunity to be able to rebut the hearsay accusations that are against you. So if the state brings information against you, and that information is truth, and you don't get the opportunity to rebut that truth, which would be the purpose of the grand jury, right? The grand jury is there that before you can be charged with a crime, you need to be able to rebut the accusations, the hearsay accusations of that crime. You can't be arrested and charged and put into jail, right? Because if you are, then you are in a situation where it is a trial by affidavit. It is an irrebutted presumption of guilt, right? If you don't have the opportunity to rebut the accusation against you, you are in an irrebuttable presumption of guilt. What is that? That is the presumption that you are guilty based upon the mere fact of being charged with a crime. Straight out of Black's Law Dictionary, guys. Straight out of it. So if you are presumed guilty based upon the mere fact of being charged with the crime, that is an irrebuttable presumption of guilt. Okay? Now, what happens with this irrebuttable presumption of guilt is that the defendant then has to go out and collect evidence to prove that they're innocent, right? And so the defendant has to go out and collect evidence to prove that they're innocent because they're already being treated as though they're guilty. They're put into jail, they're deprived of their liberty, the right to have property, use property, earn a living, take care of their family, all these things that the Constitution protects them from, then they're denied all of that automatically, and now they have to go collect evidence to prove that they are not guilty, even though they're being treated as such. Now, according to Blackstone, this is a breakdown of due process because the system is focusing on speed and efficiency as opposed to established procedures and processes. According to Blackstone, this is a situation where there is a breakdown of due process because the system is focusing on speed and efficiency. Okay? Now, so there's one other important point with information is that it shifts the burden of proof. Normally, the prosecuting attorney or the state has to prove that you're guilty beyond a reasonable doubt, right? That's what we all believe. You're innocent until proven guilty by the state. Therefore, it's the prosecutor that has to prove that you're guilty beyond a reasonable doubt, right? But not if it's an irrebuttable presumption of guilt. If it's an irrebuttable presumption of guilt, the burden of proof shifts from the prosecutor to the defendant. Now the defendant has to prove that they're innocent because of the information or the affidavit, the truth that the prosecutor brought. The purpose of the grand jury is to protect the innocent from hasty or malicious charges by an overzealous prosecutor. The purpose of the grand jury is to protect the person or the accused from the prosecutor. And yet it's the prosecutor that is bringing information, charging you with this information arbitrarily, capriciously. You don't have the opportunity to be able to confront that information. And now the prosecutor has abused the process, right? Abridged the constitutional obligation that they have to protect you, right? From hasty or malicious charges from them. And now you're presumed guilty. And now you have to go out and collect evidence to prove that you're innocent. Right? Which is a shift in the burden of proof. The United States Constitution does not allow for a shift in the burden of proof. Never. But this is what happens, right? Never, ever, ever does the defendant have to prove that they're innocent, right? It is always the prosecutor that must prove that you're guilty, but that's not what happens with this irrebuttable presumption of guilt, okay? And not only is that a violation of the United States Constitution and American legal philosophy, but that is a violation of the international human rights standards. The international human rights standards state that a defendant must never have to prove that they're innocent. It must always be the duty and responsibility of the state to prove that you're guilty. You can never place that burden upon the defendant. That would be an undue burden according to the international human rights standards. All of this is easily accessible. Everything I'm saying, you guys can go out and confirm. It's all 100% true. The problem is that this is what they do. This is what they do. And we got to get someone to step up, or some entity to step up, and that entity must be the judiciary. Because the purpose of the judiciary was to be the guardian of liberty. The purpose of the judiciary was to protect the accused from the accuser, to ensure that the accused got the rights that they're guaranteed. And that's why the Fifth Amendment says that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of grand jury. It says that because it is the judge's duty to make sure that the prosecutor brings the correct charging instrument, and if they do not, judge, you cannot hold someone over. So yes, it is the prosecutor that is abusing the process. Absolutely. Abusing the process, bringing the incorrect charging instrument, abridging their obligation of ensuring that the proper procedures are in place. But judges, you're the one committing the crime, because the Constitution placed that obligation upon you. You were the one that was supposed to make sure that before you hold this person over, you are going to guarantee that they have the rights that they're entitled to, preserved and protected by the Constitution of the United States. Judges, you are all the ones committing the crimes right now. But that's because our system was designed to place the emphasis onto you, right? You were supposed to be the guardians of liberty. You were supposed to be the honorable branch of government, the guardians of liberty, the preservers of the Constitution, and look at how much you lost your fucking way. Because there isn't a single judge in this country that even knows the Constitution, much less enforces the fucking Constitution. And you want to talk about, why we're so upset, right? It's because you judges have no clue what your fucking role in our society is, right? You're going to call up Homeland Security and say that this 100-pound fucking woman is a threat to you, right? Because you don't want to do the right thing, because you can't even argue the fucking law that she brings up because you don't even understand it. That's not a judge. That's not honorable. That's a sick, twisted fucking criminal. That's a fucking traitor. And the outcome and resolution of this issue is one that I guarantee you, Harrington, you don't want to face. But the people are fully within our right to be able to do these things morally and lawfully. But again, all that we can do is draw this line in the sand. That's all we can do. All we can do is say this is what the law says, and you guys are clearly operating outside of it. And if you're operating outside of it, that makes you a criminal. And if the judge is acting criminally, then nothing that court produces is lawful because of that judge's unlawful acts. There is nothing that happened yesterday that is lawfully binding on any party because of your criminal conduct, judge. So what do you want to do? What do you want to do, Judiciary? What do you want to do? What do you want to do, Supreme Court? Nothing you're doing is producing. Every single one of your agents have no clue what they're fucking supposed to do because you have no clue what you're supposed to do. The Supreme Court of the United States, its role was to protect, preserve, and defend the Constitution of the United States of America and ensure that we have a unbiased, neutral judiciary here in America. And you guys don't even know what the Constitution is either. You don't even fucking understand the Constitution because for 243 years, your own institution has refused to follow it. Barron versus Baltimore. Indictment by a grand jury. Right? The actual enumerated, codified requirements written in the Constitution of the United States of America, your own institution can't even read the fucking words on 4 pages. You judges are bound to ensure that there is an indictment by a grand jury before holding someone over, and you don't do it. Every single day, every single one of your agents is doing it because you guys have not ever enforced it. Who's the traitors? Who's the criminals? Right? Then you want to pretend like you don't hear. After we finished yesterday, this Homeland Security officer, or these agents, told us to take this directly to the FBI. They said, take it to the FBI right now. Go. I want you to go to the FBI today and give them the evidence that you have. You know what we did? We left the courthouse. We drove directly to the FBI of Knoxville, directly to the office, directly there.
That's actually why I didn't go back into court. I wasn't sure if we were going to talk about it.
Yeah.
That's why I didn't go back into court, is because we got the referral from the Homeland Security guy.
We went directly to the FBI of Knoxville, right? Because he told us to go there. We had a referral from him to go directly to the FBI and report the evidence that we had, right? So that's what we did. We went to the FBI. And we filled out all the paperwork, and they said, okay, we'll be right. We'll be right with you. Did anybody come out? No. There are a bunch of cowards there too. Because when you show up to a police department, you say, I have evidence of a crime. Do they say, oh, I'm sorry, there's nobody here that can take your evidence? Right? I'm sorry, someone will call you before the end of the day and then never fucking call. Right? We have evidence of a crime being committed right fucking now, FBI. You guys promised us that you were going to call us by the end of the day. That was yesterday. And did you call yesterday? No. Did you call at all today? Absolutely not. You guys are too afraid to even have a conversation with us about this issue. Cowards. Fucking cowards. That's all I can say, cowards. Right? Why don't you want to have a conversation? Because if you hear the evidence that I have, right, that's why you guys refuse to have the meeting with me in Washington, D.C., because you know that if you hear what I have to say, you have to act on it. That's why you guys wouldn't call me in. That's why you guys didn't detain me. That's why you didn't bring me into an interrogation room, because you don't want to hear what I have to say. Because if you hear what I have to say, you have to do something about it. Cowards. Cowards. FBI, you are the only entity of government that can investigate the crime of deprivation of rights under color of law. You know exactly what we have. You know the evidence that I brought forward. Prima facie evidence of per se crimes being committed prolifically across this country by every single judge, every single prosecutor, and yet you don't even want to you don't even want to hear what I have to say. Cowards. So you are cowards. Right? So that's why I'm proceeding in the manner that I am. So someone said earlier today that I need to go public with this. I am public, guys. That's exactly what I'm doing. We're going to every city council, every county commission. We're going everywhere we can to have a public hearing. We're going to make the public hear what I have to say in the city court, right? We're going to make them, and it's pissing them off, right? Good. I'm glad you guys are pissed off. You're going to be a lot more pissed off because we got a whole bunch of these that are planned, right? We're going to be heard, and if you won't hear me, right, then the public's going to hear me. And if you guys aren't even going to rebut what I have to say, that's going to look really bad for you. Because if there's nothing that you guys can even rebut, if you can't even argue this issue, right? Well, any unrebutted accusation is truth. This is going to be truth by the time we're done. So we are going public. When I was in D.C., that Sunday I did a speech, and I told them exactly what I'm about to do. I said that if you guys don't have the courage or the fortitude to step up and to address this, then I'm going to have to take this information public. And we're going to have to do this in a very, very public manner, which is exactly what we're doing, right? We're out here in public hearings, letting the public know of the treason being committed by these agents, and it's pissing them off, all right? It's pissing them off. But we like that, because if they're pissed, that means that one, they're hearing it, and two, the truth is doing the work, all right? All right. What else? There was another question. All right. So the relationship here. So the standard operating procedure. what they were trying to do, right, is they can't argue the Constitution. We know that. They can't argue the Constitution. That's the highest form of law. They lose with the Constitution. Jessica was bringing up multiple constitutional issues. Trial by jury, right? Original jurisdiction, conflict of interest, judicial recusal code, state being a party, right? The forfeiture of private property without just compensation. All of these things she brought up, and they had nothing to argue it, right? But they knew that she was going to bring those things up. So what was their strategy? Their strategy was they were going to create information, right? And have her arrested on the information so that they could end the disposition of the family matter dispute, right? Terminate her parental rights, award all the property to the opposing party, and do everything that they wanted to do, all their predetermined outcome, because she was going to be sitting in a jail somewhere, right? They were going to have her arrested on that information the day before she was supposed to go in, right? For that, and so if she would have been arrested, right, even if she would have gotten bond, she wouldn't have gotten bail or bond until the following day. Even if she got it. Because she would have had to have sat there 24 hours before the next bond hearing. And 24 hours later was after the disposition of this family court dispute. So even if she got bond, she wouldn't have been present. And if she's not present, then whatever the opposing party wanted or whatever the opposing party said would stand as truth, and she wouldn't have any ability whatsoever to rebut it. That's how they're using the criminal court to advance the civil matter, right? And then what they do is then they justify it. Because that Judge Harrington, she would have came in and said, oh my God, Miss Saxton threatened my life on, whatever, and now she's sitting in jail. And they would have completely justified all of their unlawful acts against her and everything that they did because of that criminal matter, that alleged criminal matter. And if we wouldn't have had an agent there that actually sat down with her and said, what the fuck is going on here, right? That she would have been gone. I would have seen Jess for 10 years, right? Would have been gone, just like that. And she wouldn't have gotten bail. But nonetheless, they would have terminated rights. They would have did everything that they wanted to do unconstitutionally. They would have done because of this information that was being filed in the criminal court, in the criminal matter, right, against her. So you guys want to talk about, fighting for prisoners and fighting for grand juries? Guys, this happens every single day. Every single day, someone is arrested on arbitrary and capricious allegations by a state with no foundation, no truth, and no opportunity to be able to confront those accusations or rebut them. And as a result, everybody just presumes, oh, that person's guilty. Everybody in jail and prison deserves to be there because here in America, innocence doesn't suffer. But I'm telling you right now, innocence suffers every single day. Almost happened to Jessica yesterday. 10 years, right? And if we wouldn't have had anybody else, that's exactly what would have fucking happened to her. They would have hauled her off in handcuffs, and she would have eventually pled guilty to something. Even though absolutely nothing happened. And it was an anonymous tip. How's she going to rebut an anonymous tip? She can't. Because once you are charged by information, your right to confront your accuser evaporates because the state becomes your accuser. So, the other thing I want you guys to remember here, if a judge is against you, I'm going to say, welcome to the family. Because judges go against the empaths, judges side with the narcissists. There's a spirit of deception, there's a spirit of truth. If we know that judges are deceived, they're all committing perjury, they're all liars, we know that. They're all filled with the spirit of deception. So if a judge is coming against you, I'm going to say you're on the right side. Right? You don't have the same spirit as that judge. And if that judge is siding in favor of someone, such as her ex, we know what side he's on. We know what spirit's inside him. Because if the judge is comfortable with him, he's got a lying spirit in him too. Right? So, we know that these judges are liars. We know that they're narcissists. Narcissism, right, is a mask. You got a mask that you wear, an illusion of yourself. And your greatest fear is for that mask to fall and for people to actually see you for what you really are. The liar, traitor, criminal that you really, truly are. So you walk around with this image of perfection. Oh, I'm perfect. I'm a judge. And I can't do wrong. And everything I say is the truth. And everyone else is wrong. All that is projection. All they're doing is projecting out there, trying to make people not see them for what they really are. Right? That's narcissism at its core. Right? So they project. Remember, guys, when you have a narcissist, they accuse you of what they themselves are doing. Every time. We know this. Nothing new here. So when a judge says to you, you're a criminal, you can look at that judge and say, no, you're the criminal. Right? Because inherently, that's exactly what they are. Every judge is committing perjury. Every single one of them. Perjury is a crime. Right? And by that crime, they are a criminal. That's a per se crime. It's a violation of public trust, meaning they can't be trusted to fulfill their position. Therefore, they're automatically discharged under Article 3, where it says the judges, both of the United States and of the several states, shall maintain their office while in good behavior. And the definition of good behavior is in accordance or the avoidance of criminal behavior. So if you don't avoid criminal behavior and you engage in criminal behavior, you're a criminal, and therefore you are discharged, and perjury is a crime of public trust. Everyone who's judges are not judges because they're all committing perjury. Everyone who's judges are criminals, and thus to get the attention off of them, to maintain their mask and their image of perfection, they accuse you of what they're doing. They accuse you of being a liar. They accuse you of being a criminal. But that's because they're a liar and they're a criminal. Right? This is what narcissists do. This is typical narcissism. And it's all to prevent that mask drop. But that's why I posted the video earlier today, so that you guys can understand why I'm combating this issue in this particular way. Right? We know what they are, therefore we know how we have to defeat them. That cognitive dissonance has to be combated by the truth, and that's the only thing that can beat a narcissist. Right? It's the only thing. You have to tell them the truth. And you have to let that truth do the work. Right? Because that truth is going to make that mask drop. Yesterday, this Judge Harrington, her mask dropped. Right? She doesn't know it yet, but her mask dropped. And we have more than enough evidence to prove it now. So I would say to whatever audience might be listening, you might want to either one, fix what you've done, or two, you might want to get your affairs in order. Because the mask is dropping. You're not smart enough to beat this. Right? You're a cold, weak, and timid soul, and unfortunately, cold, weak, and timid souls don't hold position of authority within our system of government. So I would recommend that you do what is necessary to fix this right away. No one needs to know, but you need to fix it. Or two, I would get your affairs in order, because criminals don't stay in office. So that's not a threat. The law is what the law is. Duralex sed lex. It's the law. It may be hard, but it's the law. And we showed you what the law was. We drew the line in the sand. We showed you you're operating outside of it. And you did not return to established law, which means that you knowingly and willingly continued to engage in that criminal behavior. And unfortunately, that makes you a criminal. Criminals are not judges. So any action produced by that criminal is no action whatsoever. It has no force or effect on any of the parties involved in the dispute, and it is as if it never even existed. That's what's happening to every one of you in your cases. Every single one of you. These are not judges. These are traitors and criminals. And you know, someone said to me a few weeks ago, they're like, you know what? Calling them that is not, you're not going to get the outcome you want. You know, you need to say that they made a mistake or an error. And I'm like, no. If you walk like a duck and you talk like a duck, I'm going to call you a duck, man. An error is not a crime. Transgressing law is a crime, right? And if you transgress the law, you are a criminal. So I'm not going to call you something that you're not. If you don't want to be a criminal, or if that offends you, then don't commit crimes. But if you're going to commit crimes, I'm going to call you what you are. And if you don't like that, awesome. Stop doing it. But I'm not going to call you, you know, anything short of what you are. If you're a criminal, I'm going to call you out for the criminal that you are. And I'm going to let you make the decision if you want to continue to be a criminal. And yesterday, you unfortunately made the decision that you're going to continue to be a criminal, despite being made aware. There is no honor in that. And if you don't have any honor, your institution has no legitimacy. That's what we're trying to prevent here. Like, you know, a complete destruction of our system of government because of these arrogant pieces of shit criminals. Right? They don't even have enough honor to protect, defend, and preserve the one thing that gives them their power. That's not a leader. But unfortunately, that's what you chose to do yesterday. So, you know, I mean, to whoever this audience might be, we know you're watching this. The only thing we're asking here, the only thing, is to step up and discharge the duties of your office. Fulfill the obligations and promises that you made to the people of the United States. And protect, defend, and preserve the one thing that created America, that created your office, and that grants you your authority. And if you do not, then you're destroying that which you are instituted to preserve. And what are you going to do when you destroy it? You lose all your power. Our system, everything that the American people believe in, you will have destroyed. I mean, I don't know why you guys can't comprehend this. FBI, we're just asking for you to address this issue. No one has to fucking go to prison. But if their convictions are unconstitutional, you have to address it. If they're acting unconstitutionally, you have to address it. Right? We're not going to address it by you ignoring it. We're going to end up with the destruction of America if you ignore it. Right? This is not going to go away. You cannot breach the Constitution. You cannot destroy it. We're not going to permit that. It's not going to go away. So I don't know. I mean, I feel like I'm I'm a fucking babysitter right now. You know, with a bunch of fucking little kids running around doing whatever the fuck they want to do. You know, you judges, you are some despicable, you know, just scum right now. Like the absolute bottom of the barrel. Like you guys sit in judgment of all these alleged criminals, and yet you guys are the most filthiest, nastiest, scummiest pieces of shit on the face of this fucking earth right now. Destroying our fucking country so that you could profit off of your fucking illegal acts. It's fucking disgusting, man. You guys are just fucking filthy, nasty, just parasites. But you don't have to be. Like you don't fucking have to be. And that's, I mean, we are being so fucking nice in how we're doing this and how we're trying. We are coming in and we are appealing to your good, honorable fucking nature that you clearly don't have. But you can. Like, I don't think that this is what you guys want to be. But take a look at yourself in the fucking mirror for 1 second, please. Right? How do you sleep at night? Right? I mean, how do you buy your daughter a fucking $200,000 fucking car, right? When you're robbing the people of their fucking, you're robbing her of $50,000. Every fucking thing that she has, you're gonna steal it from her because you're a piece of shit. I mean, you know, we can go on and on and on, right? We're gonna call you out for what you are. We're gonna continue to cross this country, and we're gonna continue to publicly speak out amongst you until the public hears. And I guarantee you that if the public hears what we have to say, it is not going to go good for any one of you. The outcome is one I guarantee you right now you do not want to encounter. So I would highly recommend that you guys just simply step up and do your job. Enforce the Constitution, or nothing you do is going to be valid. If you think for 1 second that you, 40,000 judges, have any power over 330 million people, you are painfully mistaken. If you think that law enforcement is going to stand by you, traitors, you're painfully mistaken, right? No one is going to stand by you. No one. No one is going to protect you when it comes right down to the public hearing the things that I have to say. So again, you might want to start fixing these issues, or you might want to get your affairs in order. I can't change the outcome. All I can do is expose you for the lying, treasonous, narcissist, liars that you are, or you guys can choose that that's not what you want to be. That's your choice. I will expose you for everything that you are, or you're going to stop doing it. But if you stop doing it, you must return to established rule of law immediately, and you must obey the law completely in its totality, and you must correct the unlawful acts that you have committed, right? Because that's what reconciliation is. You must reconcile from your current life to your past life. You must take a step in a different direction, and that requires action. It requires fruit to be produced. And if you don't produce the fruit, there is no action. You can say all day long that you're going to follow the Constitution, but if you don't show it by your actions, by reconciling with your criminality from the past, you're nothing but a piece of shit criminal, and that's all you're going to continue to be. Okay? That's all I can offer you guys. That's all I can offer. Judges, prosecutors, public officials, you will be exposed for every single thing that you guys have done. I promise you. And I'm telling you, there's only 2 ways I get out of this. You guys fix your criminality, or 2, God calls me home. It's the only way I get out. So, Durlex, sed lex. Law may be hard, but it's law. We will not compromise on the law. You will obey the law, and if you do not, then you will be exposed for the criminal that you are. Supreme Court of the United States is impaneled on September 1st. Today is the 23rd of July. First day of Leo season. I'm a Leo. We're going to my power season right now. We have about 37 days right now. Guys, 37 days, something around there. Until that Supreme Court is re-impaneled. I've said before, our plan right now is we're going to make enough noise that when that Supreme Court comes back and sits down back in this session, that they're going to be returning to a shitstorm that this country has never seen. I'm going to be out here. Jess and I, we're going to be out serving. They're not going to stop us. They can't stop us. We are well within our right to employ our diplomacy, to speak to the people in public hearings, and we're going to do that. Every single public hearing we can get into, we're going to make the public aware of the criminality of these judges and the criminality of these public officials until they hear us, right? That's what we're going to do. So between now and September 1st, we need to go to as many of these public hearings as possible. All of you too. We have a script for you to read, 2 pages. We have a 4-page notice that you file with the city clerk. We need you out there speaking to the public, because the issue that we're dealing with is the same issue that all of you are dealing with. If you're in family court, you're dealing with this absence of the indictment by a grand jury issue. It just happened to her yesterday, right? They're merging the criminal court with the family court. These 2 issues are interrelated. We have to make them hear this issue. And if they do, then by them hearing it, we can get this addressed. But I'm going to need help from all of you. There's only so many places that I can go, only so many meetings I can attend, right? I need you guys out there doing it too. So if you want to go to your city council meeting, go to the public hearing, and read that script, by all means. By all means. You're going to be helping not only yourself, but you're going to be helping this country, right? You're going to be helping your fellow man, your neighbor. You're going to be helping the prisoners. You're going to be helping the children. This is for the preservation of America. You guys are stepping up and saying, God damn it, that Constitution of the United States is the most important thing to this country, because nothing else makes this country a country. So that's all it is. So please, if you want that script, you can download it from justicewithoutlimits.org. That's justicewithoutlimits.org. If you guys want affidavits, we're still receiving affidavits. The court did not agree to hear the case yet, right, before they went on recess, so we're still moving forward. The next target date that we're looking at is September 1st when the court returns, right? But between now and then, we need to keep the pressure up, do as much as we can, so we're still receiving affidavits. If you want an affidavit, you can go to justicewithoutlimits.org, download it from there, both the indictment affidavit as well as the family matter affidavit. You can also go to my website, www.tanawah.com, download it from there. If it's your first time visiting that, you'll need to put in https : in order to access it, all right? But you can download the affidavits. The instruction sheets are there at both the Justice Without Limits as well as also Tanawah.com. The instruction sheet, and that tells you where you can send it. We have 1 post office box still open. The rest of them are shut down. The only one that we're still using is in North Carolina. Justin Carey, okay? Justin Carey. And I also want to say that a couple weeks ago, Justin's son was killed. A tragic accident with law enforcement, and we want to lift up our brother there. Another senseless death by these traitors. So Justin, we're sorry for your loss with your son. It was, yeah, we're sorry about that. And rest in peace to that brother. So yeah, as many of these town halls or these city council, county commissioners that we can do, the better. We need as much help as we can get from all of you. Okay, we need the help. So between now and September 1st, again, we're moving as much as we can. We're not going to let this scare us. And if they're saying to us that we're pissing people off, that's awesome. That's exactly what we want. We hope we're pissing people off. So if we're pissing people off, then we're going to continue to do it. All right, because that's what's gonna make them change. Because if we're pissing criminals off, then that means we're doing the right thing. So if you guys want to help support this, you guys know we operate on donation. Guys, we can't do this without you, right? This is what we do every single day. And so if you guys want to help, we need the help, right? This could be a lot easier than it is. Depending on the amount of money that we had, the amount of donation, this could be easy or it could be difficult. Hopefully it's going to be easy. But we have 1 state left to serve for the lower 48. That's West Virginia. Every other state's been served except for West Virginia. So West Virginia, we're going to be there soon to provide that service. But every other state, Attorney General, Supreme Court have all been served. So we got 47 done. We still have Alaska, Hawaii. We're not going to be able to drive to Alaska, Hawaii. But that doesn't mean that Alaska, Hawaii doesn't need the help, right? So the only way we could serve Alaska, Hawaii would be through funding. We would have to have a plane ticket. We'd have to have a hotel room, probably one night in both locations, right? But if someone or group wants to help facilitate that, we would be receptive to that, because we don't want to. We would like to serve all 50, but we can't drive to Alaska and Hawaii. So if anybody out there wants to support getting us there to do the things we're doing, then we would welcome that. But we have to operate within the limitations that we have, that God provides to us. Right now, we do have a hard limitation on Alaska, Hawaii. Okay, but I would like to serve them, but we can't. Okay, so if you guys want to donate, we have Cash App, Chime, Venmo, PayPal. They're all exactly the same. This is the only one we use, guys. We don't have any other Cash App, Chime, Venmo, PayPal. If anybody contacts you and asks you to donate anywhere else, it is not coming to the TUR. This is the We Shall Be Free TUR. Therefore, our Cash App, and the only one we use, is We Shall Be Free. We Shall Be Free. WESHALLBEFREE. That is the only one that we use for every single one of those. Cash App, Chime, Venmo, PayPal, We Shall Be Free. Any other Cash App, Chime, Venmo is not coming to the TUR.
And his name is Tanawah Downing. Not Tawana Downing, not Tawana Dowling.
Yeah.
There's a lot of people out there, guys. They're trying to steal money.
There's only,
guys.
this is the only profile I use. I don't have backup profiles, nothing else. All right. So if anybody contacts you and asks you or wants to friend you with a different, it's not me, guys. It's not me. This is the only one I have, the only profile. There's not any others.
I want to say this because we get a lot of questions, like people that don't have these Cash App, Chime, Venmo, PayPal. We still have to eat. So people, sometimes they'll say, can I send you a gift card? And this was within my local group. The answer is yes. When we're on the road this much, a lot of times we stop at Walmart. We have a cooler in the back, so we're making sandwiches, and we're getting ice and keeping everything cool that way, so that we can try to save money. So yes, if you don't have those apps, just send us a message, and I'll text you, because I don't like to text on these social platforms. So I'll give you my phone number, and you can send whatever you can, whatever you want in that way. So gift cards are fantastic also. And we appreciate everything.
Especially Jersey Mike's. Yeah, I've been on the road enough. I've added some pounds at Jersey Mike's. That's my favorite, guys.
But we do. What is it?
Oh, no. Yeah, Mississippi's been served, guys. Yeah, South Carolina's been served, guys. The only states left to be served: Hawaii, Alaska, West Virginia. Every other state, I have served the Attorney General and the Supreme Court, and we've now got 12 states that we've served the legislative branch through City Council or County Commissioner. Because remember, that's the lowest level of the legislative branch. So if we go and we serve a City Council, then the whole legislative branch is served, right? That's how that works. Notice the agent, just notice the principal. So when we serve an agent, City Council, we've served the principal. Now we want as many served as possible, but we need to get every single state served, right, on the legislative branch. That's what we're working on doing. So I do a shout out to Patrick. Patrick served yesterday in Taos, New Mexico. Awesome, brother. Incredible job. We had Lance, not going to say his last name, down in Texas. Lance, awesome job. You helped serve down there. We had Crystal, who served also in Texas. We had Dr. Picard, who served in California, right? We had
Toes.
Oh, we had Toes also served. Toes, you're awesome. Love you, brother. We just had Malia and Russell, Carson Russell, the Russell family up in Montana. Great duo pair. It's coming in behind us. serving together, 3 and 3.
Carla.
Yeah, so we had 3 and 3, so they served both the city and the county yesterday up in Montana. We had Carla as well, also in California.
There's
Guys,
someone else. There's other people.
Yeah, there's other people. I'm sorry, we'll get some shout outs.
Yeah.
But the thing is, you guys, is that these people are stepping up, they're reading the script, and they're being heard, guys. And we can all do this, because this issue affects every single one of us. Because any prosecutor, any judge, any law enforcement officer, any CPS agent can bring an arbitrary or capricious allegation against you for a crime that you didn't commit, and yet they're going to arrest you, hem you up, and remove all of your property, your family, your children, and they're going to do it 100% under charging by information. Because there isn't a grand jury, neutral, unbiased decision maker in the process to review the accusation against you and give you an opportunity to be able to be treated as though you're innocent before they treat you as though you're guilty.
So we're going to have a Zoom training tomorrow night. I had to create a new link because I think our Zoom got hacked last week and it was compromised. So we'll have a new link. I'll post it on all the social media and you guys can join. It's tomorrow at 8:30 Eastern. We're going to keep it to an hour. So don't.
Wait a second.
What? This tomorrow's Thursday, right?
Yeah, this one, 6. What time is it?
6.
Is it the beginning or the end?
We can stop it. We can stop.
All right, okay. All right.
You want to do 9? Can y'all do 9? Can y'all do 9 Eastern?
I'm just saying that I don't want to be in the middle of it. Was it the beginning or the end? Okay.
We'll keep you up to date. How about
Well, we didn't make a decision. I would stick with the same time. 8:30, guys.
that? Okay.
And if
8:30
we have to, we'll have to stop. Or
Yeah.
hopefully,
Okay.
yeah.
All right. Sorry. 8:30 tomorrow. We were planning to serve county commissioner tomorrow.
No.
Someone.
Okay, yeah. Okay. Okay, guys. That's it. That's all we got.
Yep.
That's all we got. Guys, listen, like everything is in our favor on this. Everything. Constitution is the highest form of law. Anything that's contrary to that is unconstitutional. Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. It's clear. You gotta have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. That's the requirement. Government must follow. Supreme Court of the United States came out in 1884 and said, states, you don't have to do indictment by a grand jury. States went out, started creating their own constitutions then, saying, oh, we're not going to do it. Because the Supreme Court of the United States said we don't have to do it. The issue here is, Supreme Court of the United States, do you have the authority constituted to be able to amend the Constitution of the United States? The answer is no. Special amending procedure of Article 5 clearly states the only way that you can change the Constitution is through an authentic act of the people, right? Has nothing to do with the judicial branch. Nor did we delegate the authority for the judicial branch to amend the law, because all legislative power is vested in Congress of the United States, right? So, Supreme Court of the United States in 1884, when you made a ruling that amended the Constitution in an other than lawful manner, what you did was seditious, what you did was unconstitutional, what you directed all the states to do was unlawful. States, you had no authority to rely upon that because you had an obligation to support the Constitution of the United States, refer to constitutional law subsection 171, right? And so when you did do that, what you produced, your inferior state statutes are unconstitutional. Therefore, every single contract that you guys are creating that relies upon your unconstitutional inferior state statute that deprives a person of something they're guaranteed by the Constitution of the United States of America, every one of those contracts are void, without force or effect, facially unconstitutional, do not exist, right? Therein lies the issue. Supreme Court of the United States, nothing that any of these courts are producing is valid or lawful or constitutional because you guys have never understood the Constitution, or better yet, never enforced the Constitution.
But they're about to.
But you're about to, right? But you're about to. Because Supreme Court of the United States, you cannot amend the Constitution of the United States. Nowhere in the four corners of the Constitution does it say that you can arrest someone and hold them over by information. by anything short of an indictment by a grand jury. And if you don't like what the Constitution requires you to do, that's fine. Go out and present your case to the people of the United States. Get them to amend the Constitution in a lawful manner. And if you do not, then what you've done is seditious. Because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. If you attempt to alter the Constitution in any manner other than what is prescribed within the special amendment procedure of Article 5, what you have produced is seditious. Right? And sedition is what leads to treason. Because anybody that creates a seditious law is committing crime of treason. It is what it is. So everything's in our favor, guys. All of these things that they're saying, states don't have to do it. Yes, they do. States are bound to the Constitution. Right? Supreme Court of the United States made a ruling. I don't give a fuck. That ruling's not law. So everything you guys need to do to stay focused on the truth is to focus on what the Constitution says. If you guys are walking around saying, someone just told me that Tanawah is full of shit, doesn't know what he's talking about, read and remind yourself what the Constitution says. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. When you walk into that courtroom and that judge says, no, I can do this, you remind yourself, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. When the prosecutor says, I don't have to do it, I can charge you by information because this state has a statute that allows me to, remind yourself, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That is the truth. And nothing can counter the truth. And that truth will set you free. Okay? It will set you free. Thank you guys so much. God bless. And we're back on the road tomorrow. We will continue to do these. But I want you guys to know that a lot of stuff we're doing, especially now, is going to be focused on a very, very specific audience, especially now that we know that audience is watching it. Okay? We know you guys are watching this, and we're glad. But we're going to start focusing these messages on you because we need you to understand the complexity and the totality of the situation that's coming your way. Because you guys are the ones that's causing all these problems. We can do this the messy way, or we can do this the easy way. The messy way is that we have to publicly show your criminality as you are standing obstinate to that notice. Or two, you guys step up, you start working with me, and we work together to fix these problems, consistent with what the law demands. Right? Messy is that you guys continue to lie and pretend like nothing's happening, in which case I'm going to tell the whole country what the law is and how you guys are violating it, or you guys can stop violating it and let's work together to fix it. That's why I say there's only two ways out. Either you guys retreat or God calls me home. Thank you. Have a good night.
Bye, guys.
Thank you, TikTok. Thank you, guys. God bless. Thank you. Thank you, YouTube. Appreciate it, guys. Thank you so much.
This studio.